Go for it.
Good morning, everyone, and welcome. This is Barry Kramer, and thank you for joining us this morning to celebrate National Disability Independence Day. As I mentioned, I'm Barry Kramer, HGAR's Fair Housing Committee Chair. I'm very pleased to introduce you to our guest speakers who will be addressing how realtors can work with people with disabilities. I will say on a personal level, many of you know me for the co-op market, and this is something that's been so important for individuals that we are working with who are disabled and looking for co-ops to make accommodations. So I'm so glad to be moderator for today's topic, and it definitely has personal interest to me. We have two speakers for today. I'm going to read both of their introductions, and then the first speaker will be Nancy Miller. So let me introduce Nancy first. Nancy D. Miller works with people of all ages that are blind and multi-disabled. She is Executive Director, CEO of Visions, Services for the Blind and Visually Impaired since 1987, and started with Visions as a summer counselor in 1971. Vision serves over 7,000 people each year with free in-home community and center-based programs. Ms. Miller serves on the Senior Advisory Commission to the New York City Department for the Aging, DFTA. She offers training and presentations on vision loss, sponsored by the New York State Office of the Aging, New York City Department of the Aging, New York State Office of Children and Family Services, nonprofit agencies, library systems, and local and national conferences. Excuse me. Nancy has a Bachelor of Science degree in Human Development from Cornell University and a Master of Science degree in Social Work from Columbia University in a Group Work and Aging. Ms. Miller is a co-founder and volunteer president of the New York Vision Rehabilitation Association, serves on the editorial board of the Journal of Gerontological Social Work, and reviewer for the Journal of Vision Impairment and Blindness. She is president and secretary of the Brooklyn Bridge Lions Club and vice president of the 500 Greenwich Street Condominium Association. She is a fellow of the Gerontological Society of America and the Hunter Brookdale Center of Healthy Aging. The National Association of Social Workers Foundation honored her with a designation Social Work Pioneer and with a Lifetime Achievement Award. She is the editor of Vision and Aging, Issues in Social Work Practice, Hayworth Press. Her awards include the Community Trailblazers Award from Beyond Focus Media of Brooklyn, Practitioner of Distinction Award from the National Rehabilitation Association, Maggie Kuhn Advocacy Award from Presbyterian Senior Services, Senator John E. Flynn Award from American Council of the Blind, New York, and Vision Serve Alliance Excellence in Leadership Award. She is married to Jerry Miller, a former nonprofit administrator and current certified orientation and mobility specialist. They are proud, very proud of their 4 children, 7 grandchildren, and 2 great-grandchildren. They enjoy straight ahead jazz music and concerts, reading, and spending time with family. So quite the amount of experience, a great bio. Welcome, Nancy. Now I'll read a little bit about John. So John P. Herrion is an attorney with extensive experience in disability rights. In March 2008, Mr. Herrion became Director of Disability Rights for the New York State Division of Human Rights. In this capacity, he assists with enforcement of the New York State's human rights law provisions that prohibit discrimination against persons with disabilities. Prior to working at the New York State Division of Human Rights, Mr. Herrion was counsel to the United Spinal Association for 12 years, where he represented and assisted persons with disabilities on a wide variety of issues relating to employment, housing, and access to places of public accommodation. Mr. Herrion has published articles and lectured extensively, including continuing legal education programs for attorneys on the rights of persons with disabilities. He is past chair and secretary of the New York City Bar Association's Committee on Legal Issues Affecting Persons with Disabilities. Mr. Harrion holds a law degree from Pace University School of Law and a Bachelor of Arts degree from Manhattan College. So again, we're very, very pleased today and very honored to have both Nancy and John with us, who bring a great deal of expertise to this topic. Nancy is going to be giving her presentation first, and she welcomes your questions to be posted in the Q&A, which you will see at the bottom of your screen, and Nancy will address those questions as she goes along. So if you have questions for Nancy during the course of her presentation, feel free to enter them into the Q&A, and she will do her best to see those and answer them right away. When we get to John's presentation, which will follow Nancy, John prefers to answer questions at the end of his presentation. So we'll do that when we get to it. But right now, if you have questions for Nancy as we progress, feel free to post those as we go along. So it gives me great pleasure now to introduce Nancy for her timely presentation.
Thank you so much. And I'm looking forward to not only presenting the information, but really having a conversation around disability and around being around people with disabilities. My experience has shown that most people are very anxious to do the right thing, to be politically correct, to communicate in the most effective way, but often out of lack of experience or discomfort or fear, people often will react in ways that are not the most helpful or the most useful. So I'm going to go through quickly a PowerPoint presentation that will give you some idea about what people with vision loss and people with disabilities are experiencing on a day-to-day basis in New York City. Next slide. Next slide. So we know that disability and people of color is a huge issue in the disability community. There are nearly 13 million people of color with disabilities in the United States, with a much, much higher prevalence rate amongst people of Latinx, Hispanic background, as well as African American and Black Americans, Asian Americans, and Native Americans. 1/5 of the nation's 61 million individuals with disabilities are people of color. Next slide. There are an estimated 126,000 New Yorkers aged 65 and over with vision loss, with 84,000 living in New York City. In New York State, the highest prevalent rate of vision loss is found in the Latinx elder population, where almost 20% of the population experiences vision loss that it cannot be corrected with regular prescription glasses, followed by the Black African American population of 7.1%, and the white population of 4.5%. Overall, the prevalence rate of vision loss is greatest in the oldest population, where it's nearly 10%. Next slide. So the goal of this discussion is really how to help you be more comfortable and more inclusive when your client maybe a person with a disability, maybe a person with vision loss, or a family member of your client is a person that experiences disabilities. So it's very important that you look internally first, wherever you work, if it's your own company or you're working for another business. It's very important that you have business practices that are inclusive and comfortable and welcoming for somebody with a disability. So for example, at Visions, we make sure that we have business cards that are available not only in print, but also in Braille and in large print for people who have some residual vision. We train our staff on all disability etiquette, because just because you work with somebody who is blind doesn't mean that you know what is proper interaction with somebody who is a wheelchair user or somebody with a mental health diagnosis. Training is really key. And we seek members of the disability community for our staff positions, including leadership, board positions, and volunteers. About a third of our staff are people who identify as having severe vision loss or blindness. So one of the questions in the Q&A is, I have a middle schooler who's been taught to see any person with a disability as someone who is special. Isn't that by nature a discriminatory statement? Why are we allowing the education system to teach that? How can we impact education nationwide? I wish I could tell you how to impact education nationwide. It's not my area of expertise, but in fact, your point is well taken, that talking about people as people with special needs or special education or specialness is in fact experienced by many people with disabilities as insulting and discriminatory. Disability is just one characteristic. It does not describe who the person is. It's a characteristic like color of their hair or color of their skin or their height or their weight. But yes, some of the language that we have feels discriminatory and in fact does separate people rather than including them. But I can't really answer the question of how do we make the change other than pointing it out, calling it out when it happens, treating people like people first, and making sure that we advocate when we hear about situations that we feel are discriminatory. Having people with disabilities give answers to those questions is one of the best ways to be inclusive. I can only speak for myself. I can't speak for the entire disability community. And as a parent of a child with vision loss, I can only speak for my child. I can't speak for the world. But being open to hearing what language is appropriate is one of the first steps. Next slide. So we try to encourage and follow universal design principles. And this goes exactly to that question about specialness. So curb cuts were originally designed for people who are wheelchair users. And then we found that they were wonderful for people who are wheeling baby carriages or for people who were wheeling packages. Curb cuts became a part of universal design, that they work for lots of different people and enable them to cross the street safely and easily. So our goal is to make everything accessible to everyone by original design. Websites have standards that must be met, and that includes your website. Any website that is open for general business should meet these accessibility standards. So when you're designing your website or updating your website, you should make sure your web designer is following the WCAG at least 2.1 standards. Your office space should be designed so it's easy for people to navigate, whether they're visually impaired or whether they're wheelchair users. Printed material should be available in text-only versions. I know you love those colored pictures and you love, pictures of yourself in your brochures, but you should always have a text-only version so that a person who uses screen reading software is able to get the text narrative unless you label every picture, and that needs to be labeled in a format that can be read by the software. Use large print, sans serif typeface, high contrast wherever possible. If you have signage, make sure it's easy to read, that you have non-glare lighting, and that you're inviting disabled individuals and people with vision loss to your strategic planning process, to your advisory groups, to your strategic initiatives about your business and your company. Next slide. Fear is our biggest obstacle. People are afraid of losing vision, and they're afraid of being around people with vision loss because it makes them uncomfortable. People fear blindness more than deafness, blindness more than having to use a wheelchair, blindness more than losing a limb, and fear blindness more than having a mental or emotional illness. Next slide. So what are the eye diseases that people are likely to be experiencing when they come to you to look for real estate or to discuss with you the real estate market? And I'm going to go through these very quickly, just so you're familiar with the names. I'm not going to go into all of the implications, but it's very likely that amongst your clients, you're going to at least experience some of these eye diseases. Next slide. Macular degeneration is very common in the older white population, and it is a loss of central vision. Next slide. Glaucoma is very common in African American, Latinx, and Asian populations of all ages, and it's generally the loss of peripheral vision. Next slide. Cataracts, you may be familiar with them. Fortunately, most cataracts can be removed safely, and the cataract surgery is 99% successful. However, some cataracts are complicated by diabetes or by glaucoma and may not be corrected. And vision through a cataract is very dull and blurry. Next slide. Diabetic retinopathy is extremely common in New York City and the surrounding suburbs. Diabetes is usually related to both a genetic predisposition as well as lifestyle. Being overweight, you are much more likely to be prone to diabetes. And with diabetes, you can either have blurred central or side vision or a blind spot. Next slide. I'm going to mention legal blindness only because in New York State, if you're legally blind, you are eligible for a whole variety of free services. And it's very important to understand that people, even with total blindness, can be completely independent. Blindness does not necessarily lead to sitting at home and not being able to navigate the world. Next slide. So looking at the eye chart, legal blindness, which is used by the Social Security Administration, is an arbitrary definition. It's used for the purpose of deciding who's eligible for benefits, but it was never a clinically evidence-based measure. It just means that in both eyes, you see worse than 20/200 acuity. So you would have difficulty seeing the large E on the eye chart if you're legally blind, even wearing glasses. Next slide. A determination of legal blindness, which is 20/200 acuity in both eyes with correction, or a visual field of less than 20 degrees, qualifies an individual for certain federal benefits and state benefits through the New York State Commission for the Blind. Next slide. What are you likely to see if somebody with vision loss comes to your office? Well, you might notice that they bump into an object that's at hip height. They might not see it. They might have difficulty reading a sign or reading paperwork. They might move hesitantly, grope for an object, touch in tentative ways. Some people have better vision in part of their visual field, so they might squint or they might tilt their head, or they might request additional lighting or a different kind of lighting, what we call task lighting, where the light is directly on the page or whatever they're trying to read or look at. The person might have difficulty recognizing faces. So we always encourage people to introduce yourself, even if you think the person knows you, they may not recognize you right away by face. They may have difficulty reading regular print or difficulty reading papers with poor contrast. How would you know? The best thing to do is ask, do you need any accommodations? If you know the person is blind or visually impaired or has any other disability, it is always appropriate to ask, is there any way I can be more helpful? Is there anything that you need me to do to make you more included in this conversation or this tour? Different people have different requirements. Some people love description, some people don't. So it's always safe and always best to ask the individual. Next slide. You might notice that somebody holds a book or other reading material close to their face. If you're eating with somebody who is visually impaired or blind, you might notice that they have more difficulty spilling liquids or pushing food off the plate. We come in, Visions as an agency, when somebody has vision loss that is so severe, it's interfering with their day-to-day function. And we teach people how to make sure that these incidents don't happen. And it can be taught using non-visual techniques. We try to prevent people from becoming withdrawn or hesitant to leave the house. You might notice physical alterations of the eyes. The eyes may be closed, they may be blurred, you may see the cataract. And in about 20% of people with vision loss, they actually will experience visual hallucinations. It is not dementia. It is the neurology and the optic nerve of the eye and the brain that are not working properly together. And it does have a name called Charles-Bonnet syndrome. Next slide. So what does Visions do? Next slide. We are one of 16 private nonprofit vision rehabilitation agencies providing free or low-cost services. In the case of Visions, all of our services are free. We offer individualized and group training and other services in the home, in the community, or at our agency. And we help many people. We are #1 in job placements of visually impaired and blind individuals in New York State. We help people of all ages to lead independent and active lives with vision loss, including working and volunteering. And Visions as a nonprofit agency, our catchment area includes all of Long Island, the 5 boroughs of New York City, and the lower Hudson Valley. Next slide. So who provides the service? We have specialists with master's degrees, certified vision rehabilitation therapists who teach independent living skills at home, how to learn Braille, and use alternate forms of communication. Orientation and mobility specialists who teach you how to safely navigate from one place to another, either using a long red and white cane, or you may be using an electronic cane or optical devices, using your smartphone and the GPS applications. Next slide. What are the skill areas that each of the specialists work on? Everything from managing your meals, communications, home management, financial management, personal management, indoor mobility, low vision aids, medication and clothing labeling, childcare, babysitting, leisure activities, independent street crossings, get around New York City as a blind person without assistance, outdoor sidewalk travel, emergency exiting, use of public transportation, navigating, development of your other senses to substitute for or supplement the function of your eyes, preparation for dog guide training, and using a human guide. So after all this training, if you have a client who is blind, they will make a great resident of any of the real estate that you are promoting. They are safe, they are trained, and they are able to manage. Next slide. For those people who are new to vision loss and are adjusting to it, we do have intake workers and licensed social workers who will help with that adjustment through supportive counseling for the individual and their family. We also have occupational therapists on staff, since many of the blind people and low vision people that we serve experience other chronic conditions or disabilities, and having a multidisciplinary team helps us address each of the functional difficulties so that people can be safe wherever they're living or working or studying or volunteering. Next slide. Low vision services and low vision eye clinics are one of the services we provide that most people don't even know exist. After you've been diagnosed with a vision loss, even with legal blindness, you still may have some remaining vision. And the low vision specialist and optometrist with special training will help you maximize whatever remains. That low vision exam really emphasizes what a person can see and how to use it to perform their daily tasks. Refraction using specially prescribed lenses to better focus and using remaining vision is part of the low vision exam. Next slide. We also teach assistive technology. So there's built-in accessibility features on smartphones, specialized applications, specialized software, and also learning how to use a variety of technology that is voice operated. It is very popular with people with vision loss. Next slide. In addition to training for independent living and independent navigation, We also help people prepare for and get work, career exploration, coaching, resume writing, preparing for a job interview. We know, because we see it, that people of all ages with vision loss can work, including older persons. We also connect people with peer support, benefits, and entitlements. There is a library specifically for people with vision loss and physical disabilities located on West 20th Street in Manhattan. Ira and Be My Eyes are phone assistants where you can call a number and a sighted person at the other end of the phone will be able to describe to you a picture that you take with your camera. So it could be reading a street sign. It could be when you're shopping, looking at the label or the price. Be My Eyes is a free service. Ira is a service that is available on many college campuses, in many businesses, and it's also by subscription. And we encourage people to get familiar with and join consumer groups like American Council of the Blind and National Federation of the Blind that are very active in the tri-state area. Next slide. So where are we located? Visions provides services in people's homes, in every neighborhood, in every borough, in every county, in our catchment area. We also have free overnight residential health, wellness, and social programs, and overnight intensive vocational rehabilitation and pre-employment services for blind youth and adults. We have the Center on Aging, which is our older adult center, located at Sellis Manor on West 23rd Street in Manhattan. And we are offering both in-person and virtual classes that have been adapted so that a person with vision loss can participate independently. We also offer social work counseling and peer support and evidence-based health programs, Tai Chi, falls prevention, walking club. Many of these classes are actually provided by blind instructors. And if you'd like to see how blind people manage independently, we invite you, come to our older adult center. We also have a community center for younger blind individuals, and you can actually watch and see how people function without vision. Next slide. Who pays for these services? If you're legally blind, if you meet that legal definition, it is free of charge, and it is paid for through the New York State Commission for the Blind, which contracts with agencies like Visions. Medicare, Medicaid, and private insurance generally does not cover vision rehabilitation devices or equipment. However, if you're a veteran, you can also get this service through the Veterans Administration, and they have a very robust and very deep provision of service for people with vision loss, whether it was while they were in service or as they're aging or out of service. Next slide. So what's disability etiquette? Next slide. These are some of the do's and don'ts. Remember that the person is not their condition. Avoid words like a victim of vision loss, or suffers from, or afflicted by. This goes to that question that was asked in the very beginning, that people with disabilities are not victims. It could be you or me at any point. It's a group that we could join at any time. So it's okay to say John is a person with vision problems, or John is a blind person, but try to stay away from the negative wording that makes that person seem like or feel like less of a person. Many people who have the legal definition of blindness do have remaining sight. So it doesn't mean they're malingering. It doesn't mean they're pretending. They may be able to see better in certain situations. Very few people are totally blind, have no vision at all. Next slide. Again, the best way to treat a person with a disability as an equal is, if you're not sure, ask. Don't assume. Everybody is unique and may have different needs and different requests, may not need anything particular at all, or may need something specific, and they will let you know. Always speak directly to the person with a disability. This is one of the most annoying situations that people tell me about all the time. A blind person and a sighted person walk into an office or walk into a restaurant, and the server or the receptionist will say, "What would he like?" Or, "How can I help you?" And it's only to the sighted person. If you want somebody to feel less than included, that's the best way, is to ignore them. So don't ignore the person with a disability. Speak to them just as you would anybody else. "How can I help you? Welcome to my office. Is there anything I can do to make this experience better for you?" Ask the person how much description they want. What format do they prefer? If you're handing out printed materials, ask them if they would prefer you to email it, so they can use their screen reading software to read it independently. It's always helpful, if you have the time, to email the information in advance, so that if you're showing an apartment or you're showing an office space, you want that individual that can't see it to have as much information about it, the description of it, in advance, so they know what questions to ask. Next slide. Always introduce yourself. Don't assume they know who you are or they remember you. After many visits or many interactions, the person might identify you by voice, but don't assume. Always identify yourself and say who you are. "Hi, I'm Nancy Miller. I'm the social worker at Visions." Speak to the person who is blind the same way that you would to anybody else. Don't shout. They're not deaf. Don't speak slower than usual. They can hear usually as well as anybody else. If they can't, they will let you know that you need to communicate in a different way. Don't speak to the companion or family member. Ask the person with vision loss direct questions. If you move or you leave the room or you're pointing something out, let the person know. "I'm going to get a pen, I'll be right back." Or, "I'm walking over to the mural." Or, "I have a piece of paper that I'm going to be describing to you." Again, they'll let you know if it's too much information, but make sure that you're including them in what you're doing. Next slide. If you encounter somebody who seems to need help, you can offer help. Just ask if they need assistance. "Can I help you?" Never touch a person who is blind without asking first. So you might say, "Hi, I'm Nancy. I'm just going to touch you so you know where I am. And I just want to know if you need any assistance." If the person says, "Yes, I'd love to take your arm," I have a photo of a person holding on to a guide. The arm is relaxed next to the side, and the grip is just above the elbow. That is called human guide technique. So if somebody who is blind is asking you to be their guide, The best way to guide them is to give them your arm and place their hand just above their elbow, or let them find it just above their elbow. It's called human guide technique because it puts the blind person just about a half a step behind you, so that if you're walking up steps or you're walking down or you're going through corners, that person will be just behind you and feel the movement of your body. Next slide. If you're giving directions and the person has asked for directions, remember to not use "it's over there" or "it's a little bit ahead." Try to be as specific as possible. We're going to walk about 5 feet and we're going to enter at the second door on your left. Be descriptive as you walk if the person wants it. You know, we're walking through an office space with many desks, and now we're coming to steps that go down. If the person does take your arm, always be a step ahead of them. And if you're on stairways, let them hold the rail, or both of you hold the rail and let them hold your shoulder. Next slide. If you're going to be sitting down to talk, the way to help a blind person into a chair is by putting their hand on the back of the side of the chair and tell them where they are. I've just put your hand on the back of the chair. The chair is facing away from you and has no arms. The person will get into the chair on their own. If you're having a meal with a blind person, use the clock system to just let them know where their food is located. Potatoes at 2 o'clock, meat at 10 o'clock. Next slide. You may encounter a client that has a dog guide who is a working dog trained to keep the blind person safe. Always get permission before interacting with or petting someone's dog guide. Don't give commands, "Rover, come over here." Commands should only be given by the owner of the dog. Blind people who want a dog guide have to go to dog guide school, and only about 10% of blind people use dog guides. They make great companions, work for 7 to 10 years, and do help older blind people stay active, or blind people of any age. You've got to walk them, feed them, take them to the vet, but they're great companions and great for safety. Next slide. So what other resources are available besides emailing me and calling Visions? If you have a situation that you'd like to discuss or you have a question to ask. Next slide. The National Eye Institute website has wonderful educational materials, research findings. If you want to get deeper into what vision loss is all about, that's a great place to go. They have health education programs and materials that you can have available in your office. We also give out free brochures of vision services. If you want to help market our free services, we'd be happy to send them to you. We also encourage people to go to the New York State Commission for the Blind website. They will tell you all of the services that are available for legally blind New Yorkers. I went over them, but they will give them in more detail and also tell you how to make a referral. You can refer them to Visions and we will get them to the commission, or you can refer to the commission themselves. And they also do public presentations. If you have a resource fair or a real estate fair, you can contact the commission and they will have one of their staff representatives there. And the American Printing House for the Blind, APH, has fantastic materials, blogs, support groups, all kinds of information. If you come across somebody who's blind or visually impaired, you can refer them to APH. They also will tell you about all the agencies that provide services around the country. So if a relative or a friend or someone you know is experiencing vision loss and they don't live in New York, you can go to APH or they can go to APH and find services in their state, in their county. Next slide. So this is how to reach me. You can absolutely use my cell phone, call me at the office. I answer emails usually within 24 hours, if not immediately. And I'm happy to be a part of any of the situations that are presented to you where you're not exactly sure what to do or you're not sure how to be most inclusive. Absolutely contact me and I will try to be as much help as I can. Thank you.
Okay, so thank you so much, Nancy, for your very informative presentation. As someone who just recently started wearing reading glasses almost all the time, I can appreciate some of your comments. I don't see any open questions in the Q&A, but I'm happy to wait a moment before John begins, just in case anyone does want to have any questions in the Q&A. If they do so quickly and immediately, we can address them. If not, we will be happy to move to John. So I'm still not seeing any questions. You did such a great job with the topic and very thorough. I'm not really seeing anything. All right. So with that being said, it's my pleasure to now introduce John Herrion, who will continue our discussion of this discrimination on disability.
Thanks so much, Barry. My name is John Harrion. I'm the Director of Disability Rights for the New York State Division of Human Rights. Really appreciate the opportunity to be with you all this morning, and for Hudson Gateway Association of Realtors for giving us this opportunity. Thank you, Nancy, for a great presentation. I learned an awful lot given the material you shared with us this morning. So a couple of things before I get started. First, I think it's terrific that the Hudson Gateway Association of Realtors is having this program. You know, it commemorates the passage of the Americans with Disabilities Act this month, which is now a little over 30 years old. And for most of my professional career, I've been able to practice in this arena, you know, civil rights for people with disabilities. And when we work with business owners or, you know, entities that are engaged in providing a business or services for a fee, you know, the smart businesses, the smart entities treat this as a customer service issue. It's more than that, of course. It's a civil rights issue. There are laws that protect people with disabilities. There are laws that include obligations for realtors and other you know, business owners to comply with to ensure that they don't discriminate against people with disabilities. But fundamentally, it comes down to customer service, you know, providing access to services, providing effective means of communication with your clients really should be no different, you know, regardless of disability or ability or color of one's skin or the language somebody speaks, you know, et cetera. So again, kudos to the Hudson Gateway Association. Barry, I noted that you are the chair of the Fair Housing Committee. Kudos for having a Fair Housing Committee and really treating this issue with, you know, I think the importance that it requires. You know, I like the word gateway in your association name because realtors really are the gateway, you know, for, you know, such a huge part of person's lives, right? Purchasing one's home or renting, you know, renting a home. You know, I remember my own experience, like my realtor became a part of my family. You know, I was in his car, he was in my car, he came and met my wife and kids, he was in the house, you know, so that relationship is really a very important one and, you know, and a fundamental one as people are looking to, you know, to find housing. So, you know, because of that, you know, the New York State Human Rights Law, which is the law my agency enforces, has very strict, you know, requirements, you know, that realtors do not engage in discrimination and are engaged in fair housing. And to that point, in discussions I had with Mike Malone and with Jana, before the program, we talked about discrimination based on disability. And, in many ways, it's not motivated by the hatred or the malevolence that exists, you know, in discrimination based on race or discrimination based on religion or sexual orientation. There are instances certainly of stigmatization and stereotyping that go with certain types of discrimination, but typically discrimination around disability is more so driven by ignorance, not knowing what the laws require. I think Nancy's coverage of the disability etiquette portions of her presentation were really outstanding, and can help a long way to get around some of that ignorance, and again, fully educating yourselves in customer service that goes hand in hand with civil rights, I think makes a lot of sense. So with that, I'll get started. Barry, if you don't mind moving to the next slide. So what I'll be covering today are the New York State Human Rights Law protections and provisions that cover people with disabilities. People always mention the Americans with Disabilities Act. It's a great law. It actually applies to housing in only very limited ways. But the New York State Human Rights Law and the Federal Fair Housing Act are the two preeminent laws, at least here in New York State, that include protections for people on a variety of protected classes. And today we'll be talking about disability. I'll be talking about the coverage of realtors, and then I'll talk a little bit about how our agency enforces those provisions. Next slide. So we cover housing. We cover private housing, public housing, rentals, co-ops, condominiums. When I get into talking about structural modifications, we sometimes at the agency will have housing providers who are respondents say that our building was grandfathered in. It was built before your law was passed. There's no grandfathering. The phrasing in the statute is existing premises. If your premises exists, it's going to be covered under the law. So we can wipe out some of those, misnomers at the beginning. Next slide, please. So when we're talking about housing providers, we're talking about owners, we're talking about lessees and sublessees, which speak to rentals. Managing agents are covered, co-ops and condos. And again, we have our coverage of real estate brokers and agents, including sales of single family homes, commercial space, and of course, residential space. And again, there's really the language in the statute is very broadly written, very broadly construed. Persons having the right to rent, to sell, rent, or lease are covered, any agent or employee of the above. Next slide. I know we're focused on disability today, but there are a variety of protected classes in both the State Human Rights Law and the Federal Fair Housing Act. You can see them all there on the slide, race, color, national origin, all the way through to military status. You can't, we don't see much in the way of military status discrimination in housing. But it is a protected class, and it's important to be mindful that there is a variety here. Next slide, please. Some new protections in the state human rights law. You cannot discriminate against somebody based upon their gender identity or expression. Source of income, somewhat new, I would say newer protection in housing. Housing providers, realtors are prohibited from discriminating against an individual, whether they're disabled or not. Source of income applies across the board. Denying somebody a housing opportunity because they use a Section 8 voucher or some other form of a source of income that they're going to use to pay for their their rental or the purchase of their home. Also, prior arrest records are also now covered. We could do a program on each of these. So if you have questions about them, I would ask if you connect with me perhaps after the program, or I can get you connected with a colleague so that we can focus on disability rights, which really is my area of focus. Next slide, please. So when we talk about the definition of disability, there's a lot of words on this slide. The takeaway is that the definition of disability under the state human rights law is very generously construed. It talks about physical, mental, or medical impairments resulting from any number of conditions which prevent the exercise of a normal bodily function. Also see a record of an impairment being covered there. We're seeing this now more and more with people who had COVID at one point in time. This was more early on in the pandemic. We were getting a lot of complaints around COVID-related discrimination. And, somebody who had COVID at one point in time and no longer has it, but is being denied a housing opportunity for some reason based upon that record of that impairment, they're going to be covered as a person with a disability. You also, people who are perceived as having a disability but are not, can also be covered if if an adverse action is being taken based upon that perception that they have a disability. Next slide, please. So I mentioned the Federal Fair Housing Act. That is a law that is considered to be substantially equivalent with the state human rights law, but there is one I'll consider major distinction, which is the definition of disability. So under the Federal Fair Housing Act, it requires a substantial limitation of a major life activity. We don't have those qualifiers under the state human rights law definition. There's no requirement that the condition be substantial. There's no requirement that it affects a major life activity. So the takeaway here is that we don't get quite so hung up on how disabled an individual is before we are more so looking at whether or not discrimination took place. That doesn't mean that we're not looking at medical documentation to support the fact that somebody's a member of a member of a protected class. Our investigators will ask for that information. But the threshold for coverage as a person with a disability is not very high to meet under the state human rights law. Next slide, please. So coverage of realtors. So I'm going to talk, the next couple of slides speak specifically to the coverage of realtors. This comes directly from the New York State Human Rights Law. And in terms of some of the prohibitions, it's unlawful to discriminate in the negotiation of a sale or rental. And this is the big one, right? Stating that a property is not available when it is, that is the big one. That is what testers, Fair Housing, Justice Center, other agencies that do testing, that is fundamentally what they're trying to get to the root of when they are doing their testing, so what you want to ensure is you don't run afoul of this. Stating something is not available because the person has a disability, because they live with a child with a disability. That is really where realtors can run afoul directly of the law. It also covers, the terms and conditions of the privileges of a sale or lease. So it's not just in the sale, it's maybe including provisions that could be, or terms, or conditions that could be considered discriminatory as part of the sale or rental. Next slide, please. It's also unlawful for real estate professionals to use any applications or advertisements that could directly or indirectly include limitations on discrimination or based on any, again, I'm talking about disability, but, any of the protected classifications. You want to watch out for language that are in the ads that could demonstrate a limitation or, in some way, shape, or form, diminish or disinclude somebody because they're living with a disability. And again, as I mentioned earlier, the coverage of realtors, because they play such an important role, because you play such an important role, in the housing process, that word gateway again comes to mind. That there's direct liability for discriminatory actions, whether or not they're requested by the client. And this is an area that you really have to be sensitive to when you're talking about disability. Making an assumption that somebody who uses a wheelchair won't be able to manage a step or any housing with steps could land you in hot water if you're not showing somebody who uses a wheelchair all of the housing opportunities or housing that's available to them. And that can be a conversation. Don't feel like you can't, as Nancy said, don't feel that you can't engage in a communication. That's probably the most important thing to do, right? So if a client shows up who's using a wheelchair, ask them, hey, some of the housing I'm going to show you includes steps or stairs. Does that, what type of challenge does that present you? Or do you have, what are your thoughts about that? And they may say, I can actually transfer out of this chair, and all I really need is a handrail to get out of those, to get up and over those 2 or 3 steps. Or, the law requires a housing provider, the owner of the apartment building, to make modifications. Yeah, I really love this apartment building. And once I get in, I'm going to ask the landlord to install a ramp or to put handrails in or to install a wheelchair lift. And all of that is compelled by the law. And I'll get into that a bit in the way of detail in a few slides. Next slide, please. So steering, again, pretty straightforward stuff here. Steering, as I'm sure you're all aware of, would be guiding or making recommendations to prospective buyers or renters, towards or away a particular neighborhood or location or school district because they have a disability, because they have a child with a disability, or because of any of the other protected classes under the state human rights law. Next slide. So again, liability of realtors, some pretty strict provisions here. Real estate professionals, including brokers, salespersons, and their employees and agents can be held liable. Okay, and again, there are damages here. It can be, there's a financial impact to engaging in unlawful conduct when it comes to fair housing. It can be compensation for financial and emotional harm. If we've had people on the witness stand talk about the devastation that they had when they were denied housing opportunities because of the color of their skin or because they had a child who had a disability. And some of the financial penalties there for that emotional harm can be substantial. Punitive damages, if it's considered to be particularly egregious, as well as civil fines and penalties. And then, of course, training and other non-monetary remedies can also be assigned in these cases. Next slide, please. We collaborate with the New York State Department of State. So all of you on the call here or on the meeting here with licenses know that they're furnished by the Department of State. And we have established a collaborative initiative with them. So if they get complaints related to unlawful fair housing practices by realtors, we can also undertake an investigation of those cases. If we get a complaint that gets filed with us based upon a realtor's unlawful, behavior, discriminatory behavior, we can share those investigations with Department of State. Department of State holds the license. Department of State can remove the license per their protocols. And we have the other penalties and leverage that exist in the state human rights law to ensure compliance with our provisions. But we do work hand in hand with Department of State on these issues. Next slide, please. So what's prohibited for housing providers? So we talked about realtors. Now we're talking about your clients, the people that you represent, if you're representing a seller or a renter. So housing providers cannot refuse to sell or rent a housing accommodation on account of a person's disability. Pretty straightforward. You can't discriminate in the terms or conditions of the sale or lease or ownership of the housing accommodation. So it doesn't have to be, I was evicted or I was denied, the opportunity, I was qualified. That's a big part of all of these cases. You do have to be qualified financially and otherwise to be able to move in. The decision, a decision based upon outside of source of income, let's leave that aside, source of income discrimination, but requiring somebody to be able to pay the rent or make the down payment, et cetera, credit scores, all of those are perfectly lawful. But if you have other terms or conditions that are associated with the deal that are considered discriminatory, that can be problematic. And for housing providers, it sometimes extends into repair issues, heat and hot water issues. Those aren't so much the concern that you have as realtors, but we do get into some of those areas when we're talking about housing providers. And again, similar prohibitions, housing providers can't use forms or applications. It's okay to use a form or application that includes a question like, do you need any form of reasonable accommodation, as part of this purchase or part of this, this agreement. That's fine. Don't be using that form if somebody answers yes to eliminate people's chances to be your clients or people's chances to find housing. That will be uncovered if that's indeed what that question is being used for, if somebody files a complaint. But if it's being used for, the opportunity to engage in an interactive process to understand what accommodations a person would need because they have a disability, that's fine. Impermissible inquiries would include list any disabilities you have, list any impairments you have, list any medications you're taking, list any past family histories of mental or medical illness. All of those types of inquiries are impermissible and can run you afoul of the law. Next slide, please. So advertising. So some of this is a bit new. We've had some legislation passed around advertising previously. So there was an exemption for owner-occupied two-family housing. They were completely exempt from the state human rights law requirements unless they advertised in a way that was discriminatory. Now, advertising in a way, so in other words, if you are, again, what are we talking about here? We are only talking about two-family homes that are owner-occupied. If there is an advertisement that is made that includes some type of discriminatory language, that unit, that housing accommodation loses all of the exemptions that it once had under the state human rights law. Previously, an owner, and I ask this question all the time when people call, is it a two-family home? Yes, it is. Is it owner-occupied? Yes, it is. We've now really reduced the area of coverage that the New York State, if not eliminated, the area of coverage the state human rights law has over this particular housing entity. The next question is, did they advertise? How did you learn about this opportunity? Oh, there was an advertisement and it included the following, phrasing. Now, if the phrasing included, limitations or discriminatory language, now it's game time. We have coverage of this entity because of the legislation that was passed that speaks to advertising and owner-occupied two-family dwellings. Next slide, please. So I think I covered this. So once that two-family owner-occupied entity has advertised in a way, if that person needs a reasonable accommodation, a parking space, something done to the unit, all of the coverages, all of the protections that exist in the state human rights law are now going to apply to that owner-occupied two-family dwelling. Next slide. And I think I have too many. I've dedicated too many slides to owner-occupied two-family dwellings. So we can go to the next slide, Barry. So reasonable modifications. We talked a little bit about this. The wheelchair user, right? I need the ramp or I need a handrail. Somebody with a visual impairment maybe needs some type of audible alarm system, smoke alarm, fire alarm, some type of system, to prompt them if they need certain types of accommodations because of a visual impairment. There's a variety of accommodations and modifications that can be done for a variety of impairments. But let me take you through a little bit of the language here in the statute. So it says housing providers must permit, at the expense of a person with a disability, for reasonable modifications of existing premises occupied or to be occupied by such person if the modifications are necessary for full enjoyment of the premises. So we're talking about permitting an individual at their expense, and I'm going to talk about some of the exceptions there. Reasonable, the word is reasonable, right? So if it's 6 or 7 steps, the idea of installing a 60 or 70 foot long ramp in order to meet the slope requirements is not going to be reasonable. There's the phrasing, existing premises. We don't care how old the building is. And it's occupied or to be occupied. I live here and I need this modification, or I'm going to move in and I need this modification. If the modifications are necessary for full enjoyment of the premises, that means that if everybody's using the front door to get in and out of the garden apartment, that's where the ramp should go, not in the back through the back door where it goes past the garbage and the boiler and it's used to bring all the furniture and garbage in and out of the unit. That's not full enjoyment of the premises. So, that's what we're talking about, reasonable accommodations in the context of housing. Next slide, please. So here's some of the examples. It can include widening of doorways, modifying kitchens or bath fixtures, counter heights. So again, this is something you want to be aware of as a realtor because these obligations exist for your client. So having somebody who has a mobility impairment or some other form of disability who's going to need this work to get done, the law compels the landlord to do these things so long as it's reasonable. Again, interior areas of the unit, the renter, the tenant is going to have to pay for that modification, but permission cannot be denied. So this should broaden the universe of housing that you're sharing with your clients who have disabilities, because there's an obligation under the law for housing providers to ensure that they are accessible, regardless of when they were built. Next slide, please. So we talked about the interior unit. So in 2010, if we're talking about common areas, okay, that front entrance to the garden apartment that everybody uses to get in and out, that's commonly used, there the landlord is required to pay for the modification so long as it's reasonable. We're not in the business of bankrupting housing providers, but if a housing provider gets sued and says it's too expensive, we're going to ask that housing provider to show us why, including looking at their financials. So common areas, laundry rooms, parking spaces, recreational areas. You have a client who has a disability or some type of an impairment, and they're talking about, hey, I love this pool here. I'd really like to use the pool, but I'm going to need a handrail installed, or I'm going to need some type of modification done so I can use the pool. Well, I now know that the New York State human rights law requires the housing provider to pay for that modification, again, so long as it's reasonable, and you would have access to this area. That, again, would encourage somebody to be your client and to want to purchase that property. Next slide, please. So accommodations are typically rules, policies, or practices. So it covers installation of a ramp in a common area. That's where that was placed. But also it can talk, Nancy mentioned guide dogs, waiving a no pet policy for a person with a disability who needs an emotional support animal, as an example. Moving a person with a disability to the top of a waiting list to get a handicapped parking space that's close to their unit. Also something that's required by law. So again, somebody who's a client of yours says, I have an emotional support animal, and you're looking at listings that say no pets, no pets, no pets. Emotional support animals are not pets. And the law requires a housing provider to waive a no pet policy for somebody with a disability who has a disability related need for the animal. Okay. And that also goes to breed restrictions and size restrictions. We oftentimes have landlords that say you can have a pet, but it cannot be any of these breeds, or it has to be under 20 pounds. Those restrictions do not apply to service animals or emotional support animals because they are not considered pets. Next slide, please. So we have a new notice requirement, brand new. The most important part of this slide is the last line. This is still very new. Some of you, if not all of you, may be aware that there is a notice requirement for housing providers that also applies to realtors, that requires tenants and prospective tenants to be put on notice that they have the right to request an accommodation. Not the right to an accommodation, but the right to request an accommodation that's related to their disability. I spoke to one of our attorneys before doing this program to gather as much information as I could about this because it's very brand new. And I was told the delivery requirement of this notice conforms to the Housing and Anti-Discrimination Disclosure Form, which most, if not all, realtors should be aware of, which is already required by the Department of State. And there is an acronym there, HADFN, HADDFN, which I'm hoping others are more familiar than I am with that acronym. But the idea is that this notice requirement can be built into this Housing and Anti-Discrimination Disclosure Form. Again, I'm happy to answer any questions about this, but this is still fairly new, very new. And I may say, let's connect after the program offline to answer specific questions about what should be in the notice, how should the notice be shared, etc. Okay, next slide. New construction. This is something that I really want to emphasize. If you are working with developers, housing providers, and they are developing or they have built and constructed new residential dwellings that have 3 or more units, they are covered. And they are required to include certain forms of accessible design and construction. So again, anything on or after March 13 of 1991, 3 or more families have the following requirements. Barry, next slide. Public use and common use portions of the dwellings are readily accessible, okay, and usable by people with disabilities. Doors have to be designed to allow passage into and within the premises that are sufficiently wide to allow persons with wheelchairs to get through them, and accessible routes. There are trainings on what the design and accessible construction requirements are. How wide should the path be? What should the slope be? Know this: if you see something that's newly constructed and there are steps into the primary entrance or the ground floor entrance, it's run afoul of the law, and there's probably a variety of other problems with it as well. And those are places that our agency actively looks for, just because there's such a lack of accessible housing for people with disabilities when new construction goes up, and it also is inaccessible. It just, it creates more of a problem, exacerbates the problem. Next slide, please. Also, interior light switches, electrical outlets, thermostats, all the environmental controls have to be in accessible location, and reinforcements have to be in the bathroom to allow later installation of grab bars. Next slide, please. So guide, hearing, and service dogs. Nancy talked about people who are blind having guide dogs, people who are deaf or hard of hearing have hearing dogs. There are other types of service dogs that are available. If the dog, and the word is dog, has been professionally trained, it goes where the person goes under the state human rights law. So guide dogs are going to be covered in that instance. And we do have cases where housing providers have said you can't bring the dog into the lobby, you can't go into the common area. Not the case under the state human rights law. The dog is going to go where the person goes. Next slide. Emotional support animals. There's no training requirement for emotional support animals, okay? They are also contemplated as forms of reasonable accommodation under both the state human rights law and the federal Fair Housing Act. So if there's a disability related need, and there's a person with a disability, and they have a disability related need for the animal, they are allowed to have that animal. And what we do is we undertake a reasonable accommodation analysis. What does that mean? It means just what I said. Does the person have a disability? Yes, they do. Is there a disability related need for the animal? Yes, there is. Are we talking about something reasonable here? Not an emotional support king cobra, or, the New York Post loves to run with these, the emotional support peacock that somehow ends up, on a Delta airline flight somewhere, and then everybody loses their mind. That's not required by the law. But regrettably, it does paint people who really do need an emotional support animal, a reasonable one, with a broad brush. And like, hey, you're gaming the system. This is outrageous. And in those instances, it is outrageous, but not for people who genuinely have a disability with a disability related need for an animal. There's a lot of medical literature out there that supports the fact that emotional support animals and assistance animals can really diminish the impact of a mental illness or a psychiatric, issue somebody's having. And so in those instances, there's coverage. Next slide, please. I think I've covered this. Landlord is entitled to medical documentation. So landlord can ask, if somebody says, can you waive a no pet policy? If it's somebody who is clearly blind and is clearly using a guide dog, we're not going to let a landlord say, I need all the medical documentation. But, there are illnesses and disabilities clearly that are invisible, mental illness that requires an emotional support animal. Landlord can then ask for medical documentation to support that. So if you are representing a client who's an owner who is now wary about somebody coming in with an emotional support animal, you can tell them two things. One, you're required by law to provide it so long as it's reasonable. But two, you can ask for medical documentation to support the request from the client. Next question, or next slide. I covered this already in terms of breed restrictions. There's no, they're prohibited from making breed restrictions or assessing fees, right? Yeah, you can bring in the animal. We have a pet fee. Emotional support animals, guide, hearing, and service animals are not pets, not allowed. Next slide. So a little bit, and I think we'll have a couple of minutes for questions. This will wrap things up. Just really briefly on the complaint process, it's very easy to file a complaint with our agency. We're considered a user-friendly alternative to the court system. You can download a complaint form, file it online. It'll get assigned to an investigator. Our investigator, we have a unit dedicated to housing investigations. We have a contract with HUD to do those investigations. And the investigator is then responsible for making a probable cause or no probable cause determination. I want to say close to 60% of our housing cases, which is high, include allegations of discrimination based on disability. That outdistances race. So if this is an area, realtors are concerned with, it's really great that we're focusing on that topic and that you have an association like Hudson Gateway to focus on this today. So probable cause doesn't get you over the finish line. It gets you to the finish line. It gets you in front of a judge, an administrative law judge. We have a prosecutions unit that's staffed with attorneys who prosecute these cases. So again, the user-friendly part of this is there's no filing fee. You don't need a lawyer. We'll assign an attorney to prosecute the case. Case goes to a public hearing. Administrative law judge makes a recommended order. Commissioner makes the final order. Next slide. And that final order can include making the housing available, making reasonable accommodations or modifications, right? Ordering that that ramp be installed or that that no pet policy be waived. Compensation, right? Somebody has been anguishing over not having their emotional support animal. We had a case where I think the woman had to climb up and down the steps out of it was outrageous, out of her wheelchair, waiting, for the accommodation to be provided, unduly so. We don't expect the ramp to be installed overnight. We know there's permitting processes and different things that have to go in. But if it looks like there was a lack of good faith, or there was an unreasonable amount of time that somebody had to wait, or it was just denied out of hand, there's going to be compensation for that, as well as out-of-pocket expenses. Next slide. Punitive damage, as we mentioned, civil fines and penalties up to $100,000. Training can be ordered, and attorney's fees. So this can get more than the compensatory damages if a realtor, if a housing provider loses this case, and we do have complainants who come with private counsel. Those attorneys can apply for attorney's fees, and that can get much more expensive than it would have cost to do the modification work to make the housing accessible. Next slide, please. So here's my contact information as well as the division's contact information. I am happy to be a resource at any time for any of you, so long as the complaint has not been filed. And I hope you never have a complaint filed against you. But if the complaint's been filed, I have to let the process, unfold. But pre-complaint, if you call me and you say, here's my situation, I'm happy to answer questions to try to make sure that the right thing is happening there. And I shared this with Jana and Michael, and told them they can share the same with the attendees or other members of the Hudson Gateway Association. So with that, Barry, I'll open it up to any questions.
Great. Thank you, John, for a wonderful presentation. There are a few questions in the Q&A. Are you able to see those?
Let's see. Yes.
I would say either one of you could answer these. I believe the first one.
It's the first one from Lee Presser. Team helped a voucher tenant find an apartment. It would have got person out of a shelter. All paperwork submitted. Agencies pay the apartment. We're going to drop ceiling expense. Or if we have the money to make modifications. So if those modifications were based upon a disability related need, okay, the tenant had a disability and there was a disability related need for the accommodation, yes, the owner would have been obligated to make the modification, but if it was the interior of the unit, would not have been required to pay for it. So they could have told the tenant, we'll allow you to do the work so long as it's reasonable. Looks like a drop ceiling here to be removed. However, you will be required to pay for it. And again, only if that modification was being requested because the person had a disability or they were living with somebody who was moving in with a disability, and the need for that modification was disability related. With rising costs of materials, is reasonable being redefined? It's not being redefined with those words, reasonable and affordable. So I'm paraphrasing some of these questions as I'm reading through them. But the question is, with rising costs of materials and renovations, is reasonable being redefined as reasonable and affordable? I mean, I think the two go hand in hand, right? So if a housing provider, were to say this is a $10,000 cost after permitting and construction and design and getting the plans, it's going to be too much. That's fine, but we're going to ask that housing provider to demonstrate that. And it might be looking at a financial record or what have you. And again, we're not in the business of bankrupting housing providers in New York State, but if there is the money there to do it, there's a capital reserve fund, there's a capital expenditure fund, there's a reasonable way to assess, shareholders there. we may very well be looking at having that modification done or something temporarily done. Can a temporary ramp be used if it does indeed create an undue hardship?
It looks like there's an additional question from Desiree Darden at 1119. You see that one as well, John?
Yeah, where may one find a list of construction requirements such as angle of ramps, heights, light switches? I have looked and cannot seem to find this information. So Desiree, there is a group, Accessibility First, and there's another group, and so they're out in Chicago, but they do trainings all across the country, and they are affiliated, or they were affiliated, I hope they still are, with HUD, Accessibility First. And they do really great trainings for architects, realtors, housing providers around those type of requirements. In New York State, there's an agency called United Spinal Association. I used to work with them, and they also have an accessibility unit that works not only with realtors and building, like with building code folks on really the technical requirements. So I would look at United Spinal Association, and I would look at Accessibility First as two resources to help with that. If you don't get anywhere, reach out to me and we'll try to get you connected. What if the pet does destroy the property? So that's a really good question, Susan. Yeah, the landlord can do whatever is required, whether it's a certified service animal or not. I should say trained service animal or not, to remove that pet and to take to recover whatever monies are needed to repair the damage done. What the landlord cannot do is speculate that because it's this type of a dog, or because it's a dog, or because it's this size of a dog, it's going to create problems or it's going to be a nuisance. If the dog does engage in nuisance behavior and it's not remedied, the landlord can take whatever lawful action is necessary to correct that. You stated that medical documentation may be requested as proof of the need for emotional support animal. Would a letter from a healthcare worker satisfy this? Yes, in most cases, and our investigators will ask for that too. Don't play doctor. Don't play doctor. If you have a good faith reason for questioning the sufficiency of something from a doctor, I'll joking, like it came from the person's dentist, right? For an emotional support animal. There's a good faith reason to follow up with some more inquiries there, right? But, absent that, don't play doctor. But if you have a good faith reason that you could articulate to an investigator at the New York State Human Rights Division to ask for more in the way of medical support for the need for the animal, in good faith, you can do that.
John, this is Nancy. I just wanted to ask the question that I answered regarding a private showing in a private home of somebody with a dog guide, and the owner did not allow any dogs in the house. So my suggestion was to ask the client if they were comfortable leaving the dog at the door and providing human guide around the tour. But that's not the legal answer. That's in the situation if the person is willing. What occurred is the client actually carried the dog around the apartment, which I think is not a good solution.
Yeah, I mean, if it's a guide dog, there should be no interference there whatsoever. If it's an emotional support animal, I would err on the side of ultimately they're going to be allowed to move in with this animal. So saying that you can't come in to look at the premises with the animal doesn't add up to me. It's starting to get down the road of, hey, I wasn't even allowed in with my emotional support animal. I didn't get this housing, and I think it was because of discrimination. Those dots are starting to get connected there, and I think that could be problematic for a housing provider or a realtor. Brian Levine is asking, what about a letter from an online service? So yeah, we'll scrutinize those, and you can too, I mean, we had one where it was pay $50 and you could print, like my investigator said, if you paid $50, you could get the certificate, just give us the $50 and give us the name of the dog and you're covered. Clearly that's not going to be something that's going to meet our specificity. So requiring something more, I think, is fine there. I would not categorize all online providers as being fraudulent, but if there's a question there, I think it's fair to follow it up. Jeanette asks, what if the prospective consumer wants an accommodation based on a close relative's disability? Good question. So the law applies to people who occupy or intend to occupy the unit. And when I say intend to occupy, I mean intend to move in with the the purchaser. So if it's a daughter who's going to live there, if it's a son or a spouse or a parent that's going to live there, they're going to be covered under the law and the accommodation. If it's somebody who's going to be visiting every now and then, not covered under the law. There's no visitors' rights for housing under the state human rights law. Susan asks, emotional support animal is so vague. If a landlord asks for more documentation, can they be sued for asking too much? If the landlord is suspicious, they have to have good faith reason for that suspicion, Susan. And I agree, it is vague. And the landlord can ask for more documentation. They can't be sued for asking for more. They can be sued if it looks like it's effectively denying the accommodation, right? So if, we get cases where the complainant will show us, this is what I showed the landlord. And it's a letter from a healthcare provider who is treating them, who says, based upon this condition, based upon these symptoms, I have prescribed or recommended that they have emotional support animal, as part of their life. And we don't write these letters. I don't try to write these letters either, but, typically those will be considered sufficient. We're looking to see, is it somebody who's treating the person, et cetera. So eventually you could get so far down the road that you will be sued if you're effectively denying it. But again, I go back to, is there a good faith reason for asking the question or having the suspicion? Linda asks, I had a problem with one of my sellers and I felt terrible. The seller claimed they had dog cat allergies. What should my reply be? I also had someone tell me they had a dog aggressive animal and not would allow a service animal. Those are really difficult, but they're not like do not pass, go, get out of jail cards. So if somebody has dog or cat allergies, trying to be sensitive to somebody, and you can ask your client too, right? Like, hopefully there's like a practical resolution here, right? Like there's like some good faith, common sense that are being used by both sides, right? So, hey, we're going to show you this house, but the person has a kid who's allergic to dogs. Maybe you don't need that emotional support animal for this visit. When it's a guide dog, all bets are off. That person needs that guide dog, to be able to get around. But, there may be instances where, you know what, I'll leave the dog in the car, or I'll, let's try to come to some common ground. And if a lawsuit does get filed, we try to get to a settlement that, is sensitive to both sides, right? Somebody who's allergic or has issues with dog aggression or some type of paranoia. Can we find some common ground so that a person with a disability who really needs the animal, has a disability related need for the animal, isn't being denied that housing because of that need? Desiree asks, isn't it so that a landlord or realtor cannot ask the nature of a disability if it is invisible? That is correct, Desiree. So once a request for reasonable accommodation has been made, okay, that opens up the conversation a bit more though, right? So initially you meet somebody and they say, look, I'm going to need an emotional support animal because I have a disability. I would stop there, okay? If the landlord or the housing provider is going to want more in the way of medical documentation to allow that tenant to move in, that's fine. That's the interactive process between the owner and the renter. Okay. I would not get involved in asking questions. Well, what is the condition? What is the impairment? Because remember, we have a really generous definition of disability. So if somebody says I'm going to need that emotional support animal because of a disability that I have, or an impairment or a condition that I have, I would leave it there. You could say to the client lawfully, okay, that's fine, but the landlord may ask you for a letter to support the fact that you have a disability and that the need for the animal is disability related. So just expect that as part of the process. No other questions?
I think there are no other questions, and I don't think, looking at the time, that we're going to actually be able to encourage any additional questions. Both Nancy and John provided their information during the course of the presentation, so I know they'll be happy to answer questions if you contact them directly. And again, they both had their contact information. I see a co-op question popped up real quick here. I guess, John, if you want to get real super quick.
I had a cooperative board ask that question. The tenant came to me and I said she didn't have to answer. Thank you. Okay. Wow. You got it right. Good job, Desiree. Good job.
So again, thank you, everyone. in helping us today to celebrate National Disability Independence Day. It is every July 26th to commemorate the signing of the American with Disability Act by President George H.W. Bush on July 26, 1990. And the purpose of the day is to raise awareness and spread the word, which we have done today, and also to facilitate more discussion of the American with Disability Act. So I also want to thank my Vice Chair, Tana McGuire, for participating and organizing today's discussion. I want to thank Gary Connolly and Jana Courier for also facilitating the discussions today. Most of all, I want to thank our two guest speakers, John Harrion and Nancy Miller, for their great presentations. And I know we all have some wonderful takeaways from the discussion today. So most of all, I want to thank all of you that joined with us today in National Disability Independence Day. Thank you for your questions and thank you for your participation. So look forward to seeing you on another fair housing event that we will again be having in the near future. So thank you, everyone, and have a great day.
Thank you, Barry. Thanks, everybody. Thanks, Nancy.